social media check-in. All right, what do we got, guys?
All right, first one. Sofal on YouTube asks, I came from Cambodia with a K1 visa in 2009, but did not marry the man. In 2012, I married my soon-to-be ex, and we have a son together. I left him because of domestic violence and had a restraining order against him. A few months after I left, I applied for VAWA. USCIS received my application in May 2019. And I also applied for a U visa. Since I stayed in the US for more than 10 years, would I be able to file for cancellation of removal or some kind of hardship that I could file to adjust my status? My 7-year-old son got hit by a car and got severe TBI, which is a traumatic brain injury last year. My father, who lives in Cambodia, has pancreatic cancer, and my grandfather is dying. I really want to visit them and have them meet my son. I can't afford any lawyers since my ex tried his best to escape from paying child support. God bless your squad.
Oh my gosh. Well, a couple things. All right. Number one, if your son has a traumatic brain injury from an accident, you have a pending personal injury case, there are funding companies that you can borrow money to go hire lawyers. That's number one. Number two, if you have a VAWA case, whether your husband was a resident or a citizen, you can file an adjustment and get advance parole to travel to Cambodia and come back. And that's what you should be doing. Yes, you would be eligible for cancellation removal if you've been here for more than 10 years. I think you were. The U visa is going to take forever. That's my answer.
All right. That's a good answer. She needs help.
Right.
Yeah. James Dube on YouTube. I applied for an SB1 visa in February of 2020, and the embassy just told me they can't process my application due to presidential proclamations 114 and 152. I passed the first part of the interview. Wouldn't I qualify for an exception as a LPR?
I would think you would. So I would give me a call and let us call the embassy because you're a lawful permanent resident.
Okay, Monefra Ramsey on YouTube asked, I entered the U.S. on an H-2B visa, which will be up October 29th, 2020. I got married to a green card holder, and he applied for my I-130 and got a receipt for September 13th, 2020. Can I apply for a job even though I haven't received the work permit yet, and how long will it take?
You cannot apply for a job until you get a work permit because you are not eligible to work.
Lil Wadi D on YouTube. A friend of mine was placed on a 3-year bar because he overstayed his visitor's visa. When he went for an LPR interview with his mom, they told him he would have his LPR visa after the bar finished. Should his mom reapply for him?
What was the bar? Bar for what?
It was a 3-year bar because he overstayed his visitor's visa.
Yes, you have to contact the U.S. Embassy, but maybe because of the proclamation, who knows? But yes, you have to contact the U.S. Embassy to get the case going again.
All right, so another long one.
Okay.
Fatima J on Facebook. I have 2 nieces, one 12 and one 15. I want to adopt them and bring them to the United States. Reason for adoption, my brother-in-law had some mental issues, and lately, due to COVID, had a huge downturn in business. He's undergoing severe depression, and my sister is a homemaker, so it's difficult for them to provide basic necessities to my nieces for the last 7 to 8 months. I'm providing them financial support to run their livelihood. They have sold their house and are currently living with my parents. But my background, I came to the U.S. from India 2015 on a student visa and did my master's in computer engineering. Got a job in an IT company as a software engineer. Got my H-1B through my company. Last year, I got married to a U.S. citizen and applied for adjustment of status. It's still pending status. Me and my wife have a stable job here. The problem is me or my wife cannot go to India to stay with my niece for 2 years. I have already stayed with my niece for at least 5 to 6 years before the marriage. Will that count as part of the 2 years? What is the adoption process?
I think you have to do it as an orphan, not as an adoption. The answer is yes, you got to live with your nieces for 2 years. You also have to have guardianship of them for 2 years. So even if you did an adoption in India, you still wouldn't get them here for at least 2 more years. Now, you can't even do anything yet because you're not the U.S. citizen. But your husband or your spouse can do an orphan petition. What would have to happen in India is that you have to strip the parents of their parental rights because they can't afford to maintain the children. Take the children out of the home, let another family member take care of them for a little bit. You support them, but the parents, they're no good parents. They can't support anybody. The father's having a mental breakdown, the mother's, in la la land. So you strip the parents of their parental rights, move the kids out of the house, let them live with somebody else temporarily. You file an orphan petition, you bring them here to complete the adoption here. That's how it would happen. It all has to happen before the child turns 16, except I heard 15 and 13, so then if you're bringing both, you have till 18. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.